Report of executive sessions held.
November 28, 2022 at 10:30 a.m.
Courts.
The motion that I'll be making in a moment pertaining to a grant that this court this county was provided by PCCD for $250,000. The reason for that grant, and I'm referring to this because Commissioner Persevers wants to bring the topic up, was for the employment of 2.5 probation officers. It's because it's necessary. It's because it was a competitive application in which very few counties got it. It took a while to convince these commissioners why that grant should be accepted. We had detailed discussions about it. Last week, the commissioners agreed to accept the grant, which I believe was a very beneficial thing on behalf of this county. The purpose of the grant, as I've indicated, is for pretrial services. Is to basically hope to streamline individuals who are in the criminal system, to have them evaluated early on, to see where they fit within guidelines, to direct them to treatment, to keep them out of prison, to make sure that those who go to prison receive the services they should in prison, and to basically complement and supplement getting people out of prison and into reentry. I thought we were beyond that, but apparently we are not. I say that because that's what these motions have to deal with that I'm going to make in a moment. The first is to establish the position of one part-time sentencing guideline technician at $17.87 per hour, which is a grade 10 step H, effective as of December 1st, 2022. The grant application, for the benefit of the board, had put in the salaries for each of these positions at $18 an hour. My understanding is, after discussions with the salary board, that this is the best that can be done. That's why I'm making the motion. I don't think the position should go vacant. I don't think it should be not created. I think it's important that it be created. What the implications are for the grant, because again, it's put in at $18 per hour, I don't know. That's a topic for your solicitor to explore. But that is my motion.
Second.
On discussion. So we just heard Commissioner Nostine mention concerns about future budget years. We'll get half the $250,000 this year, right? More or less.
Actually, the figure this year is $187,500 for the commissioner's benefit.
Right, then about another 80-some thousand the next year, so cut in
The
half.
second amount is $62,500 to be specific.
So
It's important to have information accurate.
I state my previous position that I would not accept any new hires this coming year without an offset or abolishment of at least one full-time, a minimum of two, comparable, to help keep costs down. We've had these positions that are being created. We've had the same position now really for 3 years. It's getting ready to be abolished here, matter of fact, today. And I'll hear excuses, there was COVID, we had turnover of individuals. But for 3 years we had that position, and there's no proof that one individual was diverted. Not $1 of taxpayer money was saved because of that same position that we're getting ready to abolish today, because we had a term position. The fact is, what we're getting ready to do isn't a pilot program or proof of concept. This is a potential tax burden in perpetuity on the Carbon County taxpayer without any evidence in Carbon County that it lowers costs. It might have other benefits, but from a fiscal, it doesn't lower costs. And how do we know that? Well, I made mention previously. In 2020, we had 191 inmates and we had $5.69 million prison budget. 2022, 148 inmates. We're just under $7 million. Take the per prisoner costs, it's skyrocketing. Matter of fact, that 191 to 148, I don't know if even one individual there was that reduction was associated with any diversion. Something's happening that the population is going down. But from what I understand from the 3-year program we're getting ready to finish now, the only thing that was created was a partial database. Not one diversion, a partial database. All right, I can create a partial database in a couple hours. Right? Costs at the prison are fixed. We drop 50 individuals, it's not gonna make a difference. What you're paying to run that position or that prison is going to be the same. Additionally, right, Act 57 of 2020, the courts, to include its subordinate entities, continue to be in non-compliance with Act 57. Not only do they therefore then potentially not do appropriate vetting of employees, they have the possibility when these individuals leave, some of them who could have been disciplined, those receiving law enforcement agencies have no way to know of that potential issue with that individual who they're going to hire. So we're not only impacting Carbon County, we have the potential of impacting law enforcement agencies and entities all across this country because we don't want to have the courts, or the courts don't think they have to comply with Act 57 and be part of this database. The sheriff's part of that database, why not the courts, right? I read this grant application, pretty much line by line now. The probation officer is already overtaxed, there's no doubt about it. Already overtaxed. So guess what happens when people are diverted from prison, right? They're still supervised. They're supervised by probation officers. So you think today you're getting 2 or 3 probation officers. If this is successful, which we would of course wish it would be and hope it would be, what's going to happen? In a year from now, 2 years from now, the courts are going to be coming back and saying, we need more probation officers. Again, from a fiscal perspective, this is not a good decision. That's all I have.
I think to differ on that, there's not just the cost of heating which is fixed, but also the water usage, the sewerage. And the other big one with those people are the health care of those individuals under our responsibility then it goes out. We also are providing services at the prison through MHDS, DNA, and many other sources. Our caseloads in this county are equal to 5th-class counties and maybe even higher in some others. We have an obligation to ensure that the services are provided. And if you have other recommendations on how we can reduce the population at the prison and keep these people coming back, I'm more than welcome your remarks or your comments.
Our team seems to be doing pretty well. We went from 191 to under 150, so something's being done right, be it out in the community or be it in programs that are out there. So success is happening. I hear the crime rate is going up, yet there's 50 less folks up in our prison. Seems like something's working. Let's figure out what's working. Let's put the resources towards what's working and not, which is not a proven concept, as we saw in the last 3 years here in Carbon County.
What Commissioner Lukasevich may have been aware of is that there has been an extremely aggressive drive by adult probation to get people out of prison on parole. That's one of the main reasons why people are getting out of prison right now and why the prison population has been reduced. Mr. Burke, when we had executive session, explained to this board how he has been working the position of basically re-entry that Commissioner Lukasevich is referring to. There's been a very aggressive stance on parole. Number 2, Commissioner Lukasevich has, I understand it, repeatedly brought up Act 57. He does it when I'm not in attendance. He does it when I'm not on the agenda and do not have an opportunity to respond. Today I have an opportunity to respond. And he's been told this before. So what I'm saying is now in public. I have explained to Commissioner Lukasevich on multiple occasions, not once, multiple occasions, that Act 57 is a very poorly drafted statute. were a series of articles in the Morning Call, I believe about 6 or 9 months ago, in which it confirmed that Act 57 was poorly drafted, and that it was subject to various interpretations because of its ambiguity. There is a provision, and I wasn't prepared to discuss it today, so I think my memory is correct, which talks about law enforcement officials. And as I recall, it does not specifically define what a law enforcement official is. And so the question is, does a probation officer who is under the supervision of the court, is that a law enforcement official? I had consulted with the AOPC, which is the Administrative Office of Pennsylvania Courts, and they advised me that probation officers are not subject to Act 57. They are the specialists who, they were involved in basically conversations with the legislature on Act 57. There is either an officer, head, or board created, I'm not sure which at the moment, who has issued guidelines and regulations. This is a specialty, the people who are actually enforcing Act 57. And they've concluded that probation officers under the supervision of the court are not subject to Act 57. Commissioner Lukasiewicz, for whatever reason, is unwilling to accept that explanation. I am willing to accept there can be different interpretations of Act 57. I am not willing to accuse Commissioner Lukasiewicz of illegal conduct, which he has done to these courts. So, for whatever reason, Commissioner Lukasiewicz wants to bring this topic up time and time again. I believe the court is in compliance with Act 57. It will continue to be in compliance with Act 57. What Commissioner Lukasiewicz also apparently neglects to mention is that Act 57 has a number of requirements. Already, independent of Act 57, we are doing most of those things. There are 1 or 2 we are not. So the benefits of Act 57 have voluntarily been implemented by this court. I don't know what else to say about the current motion, but I wanted to respond at least to his comments on Act 57, because I think it's appropriate.
Well, we're still in discussion, so the previous solicitor staked a position on this for the Board of Commissioners. And so I'll continue to say that position was a correct position, that the courts are not in compliance with it. There's many things in life I don't have to do, but I do them because they're the right thing. And so there might be only a few little things that the courts aren't doing, but it's the right thing to do. It's the good thing to do for this county and for other law enforcement agencies across the country that may someday take on one of our dismissed personnel. And I do believe, and our solicitor has said nothing about that an adult probation officer is not considered a law enforcement officer in regards to Act 57. Never heard that before. Again, an interpretation. Is it a poorly written statute? I'm not a legislator. I can't say. But I know it's an easy thing to comply with. Doesn't take much. The sheriff's doing it. Counties across Pennsylvania are doing it. And they're doing the right thing. The easy right? It is indeed.
There are certain law enforcement that have no choice, the sheriff's office being one of those positions. As I indicated, it is discretionary with the courts. As I've indicated, we are complying voluntarily with most of the requirements of Act 57. In addition to having consulted with the ALPC, I had also consulted with our chief probation officer at that time, Mr. Parsons. And he had recommended that we not opt into it because it was a choice, either to opt in or not participate. And we chose not to participate. To my knowledge, we are not the only court in this state who does not participate. I am unaware of any safety danger that has been incurred because of that. We consistently do what I believe is the right thing. You may disagree and you may not have a complete understanding of what's all involved, Commissioner Lukasiewicz. You were not involved in the discussions. This is the first time I'm hearing that you say you have an opinion from your solicitor. I take it you're referring to the former solicitor from what you just said. That opinion has never been made available to me to look at it, to explain it, to see if I might change my position. As I've indicated, I have consulted with the AOPC. So I would ask at this time that I be provided a copy of that opinion. I see no reason why I should not be. You apparently are relying upon it. It's an opinion you got in the course of the county solicitor's position. I think it should be available to the court.
Well, I know
Is
you
there any
think,
reason, is there any reason it cannot be provided?
well, it is attorney-client privilege first and foremost. Should I decide to release it, provide that information, I will, but I'm sure you understand better than probably almost anyone here, attorney-client privilege of those conversations.
Well, it's nice to say you have an opinion
Yeah.
for the first time here without even disclosing the basically basis of the opinion. I've given you, and explained not just today, before, why we are in compliance. I've given you the reasoning, the rationale. I've told you that the agency who is responsible for enforcing Act 57, the quote specialist in the field, has interpreted that probation officers are not subject to his provisions. There is a general principle of law throughout this country that when you have agencies who are regulating certain subjects and topics, that you defer to them for the most part because of their specialty and expertise in that field. I'm sure your counsel is aware of that legal principle. We've gone to that agency. We've seen their guidance, their recommendation. So apparently, based upon what you say, the county solicitor has given you an opinion that's contrary to the recommendation of the very agency that enforces this statute.
Well, then if MPOETC, which is running the program, provided a legal position on adult probation, we were not provided that information.
Well, don't you think there's perhaps a deficiency then, which is why I've indicated, I know you don't want to release it, that's fine, but I could respond to it further. I'm responding as much as I can in the dark to an unshown opinion.
And likewise, I am now responding to an unknown position, simply taking your word that MPOETC has ruled, being the executive agency for the database, that they have determined that adult probation officers don't fall under the definition.
I've mentioned to you on numerous occasions, Commissioner. This is not the first time you're hearing it. To imply it is
It is the first time that you've said MPOETC, or the agency as you refer to it, I believe, because you haven't said MPOETC yet, but I'm assuming that is who you're referring to, since they are the executive agency for the database. So this is the first time we've heard that.
So maybe it would be important before making accusations of illegality, that something.
Of non-compliance.
No,
I said
no,
non-compliance.
there was conversations and remarks made that the court was acting illegally. So to change semantics now is a little disingenuous.
Okay. If non-compliance is illegality in regards to compliance with Act 57, then so be it. They're synonymous terms then, that's fine with me. I will tell you, the courts are not acting in the best interest of Carbon County and other law enforcement agencies. That's clear.
Well, it's clear to a closed mind, perhaps. It's not clear to
Perhaps.
the people who are familiar with the situation, who are familiar with the subject, who are familiar with the law in the area.
That's it.
Can we move on to?
I'd like to move on.
Yeah.
I had to respond
Yeah, no,
to
fair
an
enough.
accusation here.
So,
Fair enough.
we'll get nowhere fast,
All right.
so let's call for the vote.
Yes,
Judge Nanovic,
yes.
Mr. Severcek,
Yes.
Mr. Arner,
Yes.
Mr. Lukasevich,
Yep.
Mr. Notstein.
Yes.
My second motion is to establish the position of one probation officer, one, pretrial services, at the prevailing AFSCME court-appointed professional employees union rate, effective as of December 1st, which is today, 2022.
Second.
Judge Nanovic,
Yes.
Mr. Severcek,
Yes.
Mr. Arner,
Yes.
Mr. Lukasevich,
No.
Mr. Notstein.
Yes.
Next motion is to establish the position of one probation officer, one, again, pretrial services, at the prevailing ASME court-appointed professional employees union rate, effective December 1st, 2022.
Second?
Judge Nanovic?
Yes.
Mr. Severcek?
Yeah.
Mr. Arner?
Yes.
Mr. Lukasevich?
No.
Mr. Notstein?
Yes.
I know there's another motion on my agenda. I do not intend to make that motion. I don't know why it was put on my agenda. I was not told that in advance of today's hearing. But I want to explain to you why I'm not going to make the motion, which I think we also discussed previously as well. The position that's sought to be abolished in that motion is a reentry specialist. My understanding is, at the time the position was created, it was created for a 3-year period. That is the term of the position. If I understand correctly, it's anticipated and expected, and under the current position, will expire in January, unless it were extended by subsequent motions of the salary board, which is not before us now. So it's already going to expire. To abolish that position, to me, is overkill. Secondly, I was told at a recent salary board meeting that position is funded by a grant. I truly don't know if it is or it isn't. I don't recall. It was 3 years ago. But if it is funded by a grant, I would not feel comfortable making a motion to abolish the position without first knowing if that motion could somehow be in violation of the grant terms. I do not have that information. I do not know that. I'm not going to make a motion that I don't know that consequence. Thirdly, the position, as indicated, is one that's under the union. It's in the union. I don't want to make a motion that might prompt a being agreement. I'm not saying it will. I don't know that it will. Again, I see no necessity for the motion. The reasons I've already stated. So I will not be making that motion.
I will make that motion on discussion.
Yeah, I'll second.
Okay. For myself, this motion pertains to the other three. I think when we met with adult probation, I looked at this position, and not that there were excuses, but it was COVID, wages, employees leaving. Not that there wasn't any drive to make the position work, but it failed. So in my opinion, this has to go, and I'm in favor of the other three, because when you abolish something that doesn't work, you need something to replace it, because we do have to have services for people within the county, whoever they are. And that's where my opinion is, and I think we did a little bit of research into it. It was from a grant, it was supposed to expire in January, and I'm sitting on this, that whenever we abolished a job, we always abolished it 99% of the time. And I would rather be on the safe side to make sure it's abolished, because I think I see Wayne's and Chris's both views on it. But this is an extra cost to the county. We are adding 3 new jobs. So giving one up for 3 new ones, that, and I was explained to me that some of these are basically gonna do the same thing. And the job did not fail because of lack of trying, but my trade-off is this one job has to go for the other 3. And that was my intent, and I wish on the agenda, it would have been on the agenda first to be discussed instead of being at the end. And I think we have to start watching how we make our agendas up for salary board from now on, from January 1st. Because all this salary study that we went through, if we make one motion out of line, what we did for the last year working on the salaries, it will just be thrown out the window. But that is my point on this, and I'd like to vote on it. I don't want to pass it on till next week or whatever it is.
All right, so I'll go ahead. Are you making a motion to terminate discussion? Or are you gonna let Commissioner Notstein?
So we
No,
can't
we're
even
still
discuss it.
under
We can't even
discussion.
Yeah, you
We're
can
still
still
under
discuss
discussion,
yet,
so-
but
Still
let's,
under.
My question
Unless
to
it
you,
turns-
Your Honor, is when do you plan on making an appointment effective then? Are you planning on appointing a person to fill that position at what point in time?
Which position are you talking about?
The one that we're talking about eliminating, the reentry specialist, when are you gonna, isn't that person going to be appointed to the probation officer pretrial services?
My discussions with Mr. Kimmel, who is our adult probation officer chief, is that based upon what Commissioner Lukasevich had indicated at some prior meetings, that there would likely not be an extension of the reentry position. And it's currently vacant because we've had a hard time getting people for that position. I hate to detour a little bit, but I disagree with Commissioner Arner in the sense that he's saying it's been ineffective and had no success. When we met with Mr. Berg present as well as Mr. Kimmel, I believe Mr. Berg's comment was, it's probably been about 85% accomplished, or was hoped to accomplish. So to ignore 85% to me is glossing over a result. And Mr. Berg indicated that he was the one who had backed up, as I indicated earlier in this meeting, with respect to parole, getting people on parole. Mr. Berg has been the basically slave driver, the working hard person to accomplish that. It's true, and I'm not disagreeing with Commissioner Arner, that there have been 3 individuals appointed to that position since its inception. COVID had some play in why it hasn't been filled entirely, but COVID can't be used for an excuse for 3 years. I'm not offering COVID as an excuse for 3 years. But my recollection is the first person who was appointed to the position, and this is not critical of motherhood in any way, became pregnant twice, and therefore had to take leaves. Another person who was in that office, a person by the name of Mr. Isles, who the commissioners may know about, was doing very well from everything I've heard. And it was hoped that he would stay there. Unfortunately, because of the pay salaries that this county has given, he could not afford financially to stay in the position. And therefore, he was offered a position somewhere else. And it was, how can you refuse it when you're giving those benefits? The third person is an individual who had been in probation down in North Carolina, transferred here, and unfortunately, she was in the position a short time, I believe only a month or 2. I don't want to be specific, but somewhere in that area. And it didn't work out, so we had to leave her go. So yes, the position is currently vacant. Getting back to Commissioner Wilson's question to the court. Mr. Kimmel has been interviewing to fill that position. He was not aware, nor was I recently, because time passes, that the position does expire in January. But Commissioner Lukasevich brought that to our attention, and I appreciate that. I was on, and it was in the salary board minutes, no question about it. So he's been interviewing for the position, and I told Mr. Kimmel that we should, those people we interview, we should tell them that it's not anticipated the position will be on January. But because there is some overlap, and it's not 100% overlap by any means, because we're talking about pretrial services in the 3 positions we spoke about earlier today, and we're talking about re-entry in the position that's about to expire. So one is at the incoming stream of criminal proceedings, the other is at the outgoing, the other end. But I told him that since there is some overlap, and since hopefully we will have these 3 positions, that yes, we should tell these individuals we're interviewing that if we accept them, that even though that position will be expiring, we would then transfer them over to one of these 2 new positions full-time. So that's the answer I have to your attorney.
I think that, the county process, the Board of Commissioners procedure is salary board procedures to establish, abolish. This simply, for no other reason, to keep everything clean, to keep the historical record straight, abolishment is an appropriate parliamentary action to take.
And like back to mine, I think when we had our discussion before, I think it was like, and I said, I don't want to say it failed, like you said, 85% worked. But this person, if we'd abolish it, this person would lose their job. And I didn't want that. But the way it was explained to me, this person's job that would be moved up to one of these 3 positions here is very similar to one that we're abolishing. So we would have somebody right on board to do this instead of stalling. We can't keep stalling all the time. This person can move right into that position, and then we got 2 more people to hire. And there's people that need help in Carbon County.
There's overlap, but
Yeah.
I'm just trying to perhaps help you understand. Pretrial means before trial, obviously. So that's getting people in when they first get charged, when they're first in the system, is to evaluate them early on and hopefully, in some circumstances, avoid them even having to go to prison as they're waiting trial. It's to help establish bail at the magistrate level so that this information can be provided to the magistrate. It's all pre-trial. It's to have guidelines prepared so that that's available not only to the magistrates, but to the judges of this county, to see what the prior criminal record of each of these people are, to see if they are a danger to society for other reasons, such as addictions or mental health issues, things of that nature. So help basically set bail, because maybe bail can be unsecured, meaning there's no need to have them post something just based on their past history. There may be others that it would show there's a reason to believe they're going to continue committing crime, and so bail is necessary, and they may have to go to prison. That's all pre-trial. Re-entry is after they are in prison. They've already gone through the system, they've been convicted, they're sentenced. And the question is how to get them out of prison safely as soon as possible. And that involves evaluation of them as well, and to see what their needs are, and to give them direction of where to go to get treatment. So yes, there's an umbrella of assessments that's covering both pretrial and reentry, but it's different ends of the process. So yes, there's overlap, but it's not identical. They do serve different functions, and reentry is an important part. As I've said at least twice, that is because of the reentry, the efforts of getting people out on parole as soon as possible, that is at least in part. I can't give you a dollar figure as Commissioner Lukasevich would like to hear. I can't tell you that. But it's to get them out of prison for their benefit, for their family's benefit, for the county's benefit. But it is two ends of a system.
Judge, do we know if that person is willing to take this other position?
I don't know at this point. I haven't spoken to, I mean, this was only discussed, I think, within the past week, if I recall.
I see no reason why it's gonna go away anyway in January, but just to make sure this person, I don't even know if they were approached for this position or not, if they'd be willing to take it. And I just see no reason that we should abolish it at this point in time until that appointment is made. If it's made before January 5th, fine, we just don't fill it, it's going away anyway. Who's gonna take a job that's gonna expire in 2 or 3 weeks? So, that's my comment. Let's call for a vote.
Judge Nanovic?
No.
Mr. Surachek?
Yes.
Mr. Arner?
Yes.
Mr. Lukasevich?
Yes.
Mr. Notstein?
No.
Well, thank you very much. I think we had a good back and forth discussion. I hope I haven't offended anyone, that's not my intent. But I am glad that I was given an opportunity to at least reply to the issue on Act 57. Thank you. Have a
We
good
all
day.
go away friends yet. Remember